Please be seated. We have 3 cases on the docket this afternoon. We will take a break after the first case, and we invite the attorneys to join us in the attorneys' lounge for coffee, if you'd like. We're going to take the cases in the order that they appear. I'm going to make an announcement for all appellants. If you want to reserve time for rebuttal, please let me know. I'll try to remind you, but ultimately you're going to be responsible because the yellow light will come on for your rebuttal time on the clock, so you know what's there. Are both sides ready on the first case?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. May it please the Court, Counsel Robert Emanuel here as counsel for the appellant. I would like to reserve 3 minutes. The contract between my client and the seller, the Rattikins, contained a mandatory disclosure provision in paragraph 7. Under that paragraph 7, the seller was required to disclose to my client any material facts that affected the value of the property. It is undisputed in the record before this Court that the seller, the Rattikins, did not disclose a material fact to my client, that is, that the property was burdened with covenants that would preclude the specific use that my client planned to use the property for and for which my client purchased the property.
If there really is a duty to disclose, isn't that duty to disclose things that would not appear in the record? I mean, my concern here is that the deed restrictions were in the chain of title. And how do we forgive a person from not being aware of or alert what's in the chain of title? That seems like it opens up a real Pandora's box.
Well, Judge Wolf, I'll respond this way. The facts here are very unique. First of all, Mr. Rattikin, the seller, was an experienced real estate attorney. He had expressed knowledge of these covenants. He knew that my client wished to purchase the property to build 4 condominiums which were not allowed under the covenants. Having that knowledge, he still allowed his exclusive sales representative to expressly represent to my client that he could build the 4 condominiums and expressly represent to my client that there were no covenants or restrictions that would prevent him from doing so. And, Your Honor, under the paragraph 7, our position is clearly when the seller knew that his agent was misrepresenting to my client the use for which the property could be put, he had an
You're taking one provision out of the contract, paragraph 7. We have a contract that was submitted by your client that was rejected by the other side, basically saying that, this is as is, we're making no representations. Paragraph 18, for instance, said that you have to verify all facts and representations are important and consult an appropriate professional for legal advice. So taking this contract as a whole, did they really have a responsibility under the contract to provide any further information?
Yes, Your Honor, they did. And I think the SVRUD, S-Y-V-R-U-D case that we cite has almost exactly the same 2 contractual provisions. That is, on the one hand, an as-is provision. On the other hand, a mandatory disclosure requirement. And what that court held, which I think is appropriate, is the seller then has 2 responsibilities. One, to mandatorily disclose everything that material affects the value, and then to say, having made that disclosure, I'm making no representations about what you can do. But the disclosure still...
What was the failure to disclose in that particular case?
Pardon you?
What was the failure to disclose? What information was not disclosed in that particular case?
In the SVRUD case, Your Honor, as I recall, what was not disclosed there was the fact that the property had been, I think, subdivided in violation of the requirements of the county and therefore could not be constructed on the way it was represented. Here, what was not disclosed was Mr. Rattikin knew that because of the restrictive covenant, my client cannot build 4 condominiums on the property. Mr. Rattikin knew his exclusive sales agent was making that express representation to my client.
Wasn't your client put on notice, though, by the fact that Mr. Rattikin deleted from the original offer the contingency that your client put on with regard to the county's development order with regard to the condos?
Well, Judge Rowe, I think deleting that contingency did not delete his requirement to make the disclosure. And again...
Wasn't that adequate, though, to put your client on notice that there may be a problem with development of the condominium complex on the land?
Judge Rowe, after that decision was made, after that change was made, my client asked his exclusive sales agent, wait a minute, your client's put this as-is language in there. I'm not the right buyer because I don't want to buy this property unless I can build the condos. His sales agents told my client, notwithstanding the as-is provision, I've checked with the seller, you can build the condos. That's what was represented to my client after the change was made in the contract. And so, Judge Rowe, there were really two violations of paragraph 7 here. First, you had a misrepresentation by the seller's exclusive agent as to the use for which the property could be put. Clearly a violation of paragraph 7. Secondly, once Mr. Rattikin was informed by his own sales agent that she was making those representations, and he knew those representations were false, he should have either corrected her and required her to make an accurate disclosure, or he should have made that accurate disclosure himself. He chose to do neither. And I think clearly under the Zvara case, the fact that there's an as-is provision does not preclude the owner's, the seller's responsibility to make the mandatory disclosure.
What about at least the dicta in the Azum or the Azum case that seems to indicate that items in the chain of title cannot be the basis of negligent misrepresentation?
Your Honor, if you look at the Azum case, it clearly, what it says is clearly revealed information may be a stop. But here, Your Honor, I think the facts are interesting. Mr. Rattikin supplied his exclusive sales agent with a copy of this covenant. It was not readable. His agent called him and says, I can't read what this covenant says. His agent then threw the covenant away without giving a copy to my client.
But it was still on the chain of title. I understand the one that he produced was illegible. But is there any dispute that this document with the restrictive covenant was in the chain of title?
Your Honor, no, but here's the point. Mr. Rattikin then said to his sales agent, I'll send you the book and page. He sent her the book and page. She went to the county and still couldn't find it. It was not in the deed into the Rattikins. It was a deed back in the 50s. So is it back in the chain of title, Your Honor? The answer to that is correct. But as a matter of law, is it clearly revealed? The answer to that is no. And although Azam talks about that, Your Honor, they also go on to discuss that in a situation when you're talking about intentional fraud, that a lack of possible due diligence by the buyer is not going to let a seller use that as a shield. Azam says as follows, we affirm the commitment of our law to prohibit one who purposely uses false information to induce another into a transaction from profiting from such wrongdoing. Here it is undisputed Mr. Rattikin knew the covenant existed, knew the covenant precluded the very use for which my client wished to purchase the property. Mr. Rattikin knew his exclusive sales agent was expressly representing to my client he could build what he was purchasing the property for, and yet he failed to either direct his sales agent to make an accurate disclosure or failed to make an accurate disclosure himself. And that's exactly the express fraud that Azam talked about, Your Honor, in the site I just gave you. Here, the covenant was buried back in a deed in the 50s. Was not legible. His own sales agent couldn't find it in the public records when he gave her the book and page to find it. And yet, Judge Green below, as a matter of law, said my client, who is not a lawyer, is not a title agent, as a matter of law, should be bound to have known that in the face of express representations by the sales agent, after my client raised a question about the as-is provision, Judge Rowe, asked a question, I'm not your person, the deposition testimony is. I'm not your person because I don't want to buy this property unless I know I can build a condominium. Her response to him was, I talked to the seller. The as-is provision will not preclude you from doing so. And what is crucial, that was during my client's due diligence period where even at that late date, if an accurate representation had been made by either the sales agent or Mr. Rattikin, my client would have exercised his option out of the agreement.
Okay, I'd like to switch to another topic while you have time. And
yes, Your Honor.
You mentioned the due diligence period. Isn't it undisputed that the appraisal that was in question here was delivered after the due diligence period was over?
That is correct, Your Honor. But I think
explain to me how that would support a cause of action then against the appraiser.
Your Honor, it's very simple. Again, the undisputed testimony of my client is if the appraisal had been accurate and would have appraised the property for about half of what the appraisal actually said, then, number one, the bank would not have funded the loan because there would not have been sufficient value in the collateral. The bank would not have funded the loan. My client would not have closed on the loan because my client then would have been apprised that he had been defrauded. My client, frankly, would have demanded a refund of his $100,000 binder from the seller, and if the seller did not return it, my client would have filed a lawsuit against the seller. And, Your Honor, with regard to the
Okay, well, let me ask another question.
Sure.
If we find, as to Mr. Rattikin, I know don't agree with this, but if we find that your client was on notice or, by the chain of title, as to Mr. Rattikin, do you have a cause of action against the appraiser at that point?
Yes, Your Honor, I think I do. Because, again,
wouldn't the knowledge element go to the actions against the appraiser as well?
Well, Your Honor, I disagree for this reason. I think still the appraisal would have been provided and my client would have, at a minimum, not closed on the transaction and taken his risk with Mr. Rattikin. But, Your Honor, again, if you look at the unique facts in this case and our claim against Flagg for a moment, here, unlike the other cases that Flagg relies upon, all of the dealings were between my client and the appraiser. My client was an existing client of the appraiser. My client made the contact with the appraiser and asked the appraiser to perform an appraisal for him. Told him that a letter would be coming from a friend of my client's at Compass Bank. That letter came from that friend of my client. Compass Bank had no further involvement in the matter. They were never going to make the loan. Flagg was expressly notified of that by my client. Compass never made the loan. The loan was made by another bank, BB&T. A copy of the appraisal was provided to my client, who then provided it to BB&T. And so, Your Honor, here...
So your argument is that they were on notice that your client was going to rely on this appraisal, and that differentiates this case from...
Yes, Your Honor. If you look at all the other cases, Albright and the other ones, what they really stand and fall on is two things. Number one is the lender for whom the appraisal was performed actually did the deal, actually made a loan. Second, that there was very little or no dealing between the third party attempting to make a claim against the appraiser, the borrower, and...
You're down to your 3 minutes.
Thank you, Your Honor.
Good morning. Ken Bell on behalf of the Rattikins. I will yield any time necessary to my points to the issues that were addressed by Mr. Emanuel. I think, Your Honor, Judge Wolf, you hit it right on the head. If you were to accept Mr. Emanuel's argument, you will open up a Pandora's box. There's a plethora of cases in the second, the third, the fourth, and the fifth DCA that all stand for the proposition that if you deal with the issue in the written contract expressly and sufficiently, that one does not have a cause of action for oral misrepresentation that occurred some time before. And that's exactly what happened.
What if it rises to the level of actual fraud?
Sir?
What if it rises to the level of actual fraud?
I think even in the case, that's what the case law says. It says a party cannot recover for an alleged misrepresentation. They don't limit it to whether it's a negligent misrepresentation or fraudulent misrepresentation, because the key is, sure, we don't want to encourage people to make misrepresentations, but we also have to recognize the importance, and this is the Pandora's box, to binding people to their written contracts. Here you had an arm-length contract between two sophisticated people. The buyer and the seller were both sophisticated. He being Mr. Moe, presented an offer that included a condition on me getting a development order for 4 condominiums. That was rejected. There was a contract sent back to him that added a special condition that says, I, as a seller, and we agree, buyer, that I, the seller, am not holding out or warranting your right to use the property for any reason whatsoever.
You know, this is an interesting case in that it seems that you have a seller who, at the very least, engaged in deception, and that he knew that this buyer wanted to build 4 condominium units on the property. He knew, and looking at the briefs and the record, he knew that his agent had told the buyer, and I know we're assuming she's an agent for purposes of the summary judgment, that she had told the buyer, yes, I've checked with growth management, I checked the official records book, and there's no restriction on building condominiums. Whether she was being purposely deceptive or not is unclear, because she may have just been negligent. But the seller knew that the restrictive covenants prohibited condominium building. Now, the interesting thing about this case is, you're right, the buyer then knew that his condition that I want to be able to build condos has been rejected. And he's buying an as-is property, sort of hoping that he can build condominiums. So it seems that we have, and I don't say this lightly, but it seems like on the facts here we have, at the very least, a deceptive seller and a buyer willing to hope he can overcome, he can engage in a contract that says as is. And you think under ASM in those cases you cited that conduct is still subsumed within the contract?
Well, I think we don't. That every real estate transaction is open for, like in this case, 3 years later, a buyer who's unable to sell the property coming back and saying, well, you made this representation. That's not included in the written contract. Not only not included, so this isn't merely a merger integration clause issue. This is the issue where the specific question of the use of the property is expressly dealt with and disaffirmed. And they did the closing. The title commitment was issued that showed the restrictions in the title commitment. The deed was issued subject to the restrictions.
I thought, and your brief said this, the title commitment wasn't received until either simultaneous with the closing or after the closing.
The record's not fully clear for purposes of summary judgment. It was issued before and sent to the attorney, to Mr. Moe's attorney. It's not absolutely clear. It was a few days before the closing, but he still waits 3 years afterwards to bring in, and that's really the Pandora's box.
And he still signs an as-is contract, and he still signs a contract that specifically said, no, we're not going to warranty that you can build condominiums. No, we're not going to allow you any time to get a development order. In fact, we're giving you 10 days to buy a $4 million piece of property. That's your due diligence period. And I know you can't build condominiums. I know there's a restrictive covenant. But I'm giving you an as-is contract, and if you want to hope and dream and speculate that you can build condominiums, then that's your problem. But I know that there's a restrictive covenant. So tell me how that works in paragraph 7.
Well, paragraph 7, that's interesting. They didn't bring a breach of contract claim.
Right.
This is a fraudulent misrepresentation claim. And the contract deals with the issue. So this is really the first time they're really making the argument. They made it in the reply brief on paragraph 7. So I think if you look at paragraph 13, what it expressly says, any handwritten or typewritten terms prevail over any other condition in the contract. So even accepting their argument, the paragraph 7 gave some duty to disclose, the addendum specifically says, I'm not holding out or making any warrant of representation on how you can use the property based upon any restrictions or otherwise.
Well, does the subsequent representation by the agent that the property could be used to develop condos after the counteroffer was made, along with the fact that the chain of title wasn't I don't want to say readily observable, but wasn't discovered by the buyer, does that take this out of the Azam case? And I
don't think it does, and I think that's the importance of the Azam case, because everybody really knew about it except Mr. Moe. The seller knew about it, and he said when he was informed by the realtor, he said, well, how's he going to get around these restrictions? And so he faxes a copy of them twice to his realtor, to the realtor. They didn't even have a listing agreement at the time, but faxes a copy to her. They're illegible. So he sends her the deed book. So it's a comedy of errors in finding them. But the contract says don't rely on me as the realtor when you need to rely on a surveyor or a title examiner or a lawyer or whatever. Sure enough, the title commitment was issued pursuant to paragraph 10 of the contract. Paragraph 10 of the contract says my obligation as the buyer is to give you a warranty deed subject to the restrictions of record, which was done. The title company found the defects, showed it in the title commitment policy. It was in the warranty deed. So at closing, he at least had the warranty deed. No, the warranty deed is something that you see when you sign the closing documents. So the Pandora's box is enormous. Let's just make it a simple residential transaction, and I go and I want to buy a house, and I want to put a 3-car garage with an apartment in the back, and it has restrictions that disallow it.
Well, given the fact that even the seller's agent had difficulty finding this title defect, do you assert that it was readily observable in the chain of title?
It was readily observable in the chain of title. And I don't think there's any, if you go back and look at the cases the Supreme Court cites in the Zom, it lists several cases in there, and it says the imputed knowledge is in there, whether it's in the deed to the person or in a prior chain of title. And the law in Florida is clear, and it would be a huge mistake, respectively, if this Court were to say that this evidence of title was not sufficiently clear. And I think I need to yield my time. Thank you.
You had somebody grabbing at your tail.
Hey, please, the Court. My name is Susan St. John. I'm with the law firm of Rudy McCloskey. Here with me today is Paul Admonson. We represent Fruederker Lowry Appraisal Group, Inc., co-appellee in this case. I'd like to first address the question of the appraisal being after the due diligence period. It was well after the due diligence period. It was requested well after the due diligence period. The record shows it was requested May 18, 2005, many days past the 10-day due diligence period. Additionally, there was no contingency for financing in the contract itself. So,
could you slow down a little bit, please?
Pardon?
Slow down a little bit.
Yes, Your Honor, I apologize. Additionally, unlike Recora, where there was a contingency provision for financing in that contract agreement, there was no contingency provision in the purchase and sale agreement here.
But there had been discussions prior to the due diligence period. Had there not been discussions between Mr. Moe and the appraiser?
Based on the record and the emails that Mr. Moe sent Tom Owen at Branch Banking and Trust, those occurred approximately May 18, 2005. Again, that is well after the due diligence period. And then Compass Bank's request was May 18, 2005. Their acceptance of Roger Lowry's agreement and fee and proposed project was faxed back to Flag on May 27, 2005. Again, we are well past the due diligence period. Now, appellant has said that if the appraisal had been correct, they would not have proceeded to close on the loan. The appraisal followed the USPAP guidelines. USPAP is the Uniform Standards of Professional Appraisal Practice. It requires a 3-year look-back period under Standards Rule 1-5, which is in the record, 1157 to 1159. Flag went beyond these 3 years and reviewed the 1979 deed, which contained no restrictions. So they have followed USPAP. That is in the record at 1216 and 1337 and 38. Inspecting title to the property is beyond what an appraiser is required to do. They are not title examiners, and they do not prepare abstracts of title. Reviewing additional and older deeds is not a requirement for performing an appraisal. Additionally, there are express limitations and restrictions in the appraisal itself. One of the things that the appraisal tells you on page 1303 is that information provided by others is believed to be reliable. No warranty is given for accuracy. Mr. Moe, facts...
I'd like to address one thing, though. I understand those arguments you're making right now.
Yes, sir.
This whole question of being in privity or being someone that the appraiser had a duty to, most of those cases that we're looking at, they're directly where you have conversations with the bank, you're doing the appraisal for the bank. Here, there are conversations between Mr. Moe and the appraiser. They know that Compass Bank isn't going to be, taking the facts as true, they know Compass Bank is not going to be using the appraisal, that the ultimate user is going to be Mr. Moe. Under those circumstances, doesn't the appraiser owe a duty to Mr. Moe? I'm having problems
No, Your Honor.
Taking those facts and saying we just don't have a limited privity anymore. I mean,
we do not believe...
The cases talk about those people that are going to rely on the information. And clearly, if you take their facts as true, the appraiser here knew that Mr. Moe was going to rely on this information.
The appraisal was specifically performed for a bank. Here it was Compass Bank.
I understand the ordering was,
yes, Your Honor.
Is it limited to only those people that order the appraisal, or is it limited to those people that the appraiser knew or should have known were going to be relying on the appraisal?
Well, Your Honor, that is a good question, and my research tells me that it is limited to the people that are in the limited recovery group. And we believe that by the restrictions in the appraisal itself, and I understand you acknowledge that argument, that does provide a limitation. We believe it's irrelevant that Mr. Moe orchestrated who would be providing the lending by taking the appraisal and giving it over to Branch Banking and Trust. Why would Branch Banking and Trust take an appraisal that was not prepared for them when it specifically says don't use it unless you have written authorization? So they assume some risk in providing a loan. They are not here today in front of us involved in this case.
So he knew Compass Bank wasn't going to be using this appraisal. The appraiser had a duty to no one under your circumstances, right?
No, Your Honor, that's not what I'm saying. They did have a duty.
Well, who would they have a duty to?
They had a duty to Compass Bank. It is a good question of whether there would be a duty to Branch Banking and Trust. We don't know that. That's not the question before us in this case. That's not what has been alleged in the amended complaint. And Branch Banking and Trust did not join in this case as a co-plaintiff. So we believe that, we believe that Max Mitchell is correct in that if there's negligence, it is under negligent misrepresentation. We don't believe that Mr. Moe falls within, or Moe Real Estate falls within that protected group of individuals. We also believe that the contract speaks for itself and that it gave a 10-day due diligence period. And additionally, paragraph 15 stated that there was specific performance if the buyer defaulted. So the buyer could not simply walk away here, even if the appraisal had come in at $100,000. One, he had no contingency provision in his financing agreement. And the contract itself says if you default, you still have to close. And that's what has happened here. They have moved forward. They closed the deal. Mr. Moe's unhappy with this deal, and he's really seeking to blame others for actions he did not take himself. Thank you, Your Honor.
Thank you.
Judge Thomas and Judge Roll, I think you hit the nail on the head with regard to what really went on in this case. It's clear that Mr. Rattikin knew that my client could not use the property for the purpose he was purchasing it. Paragraph 7 of the contract had a mandatory disclosure requirement.
But I mean, your opposing counsel's comment seems well taken, that, as I recall, I saw that raised primarily in the reply brief, and it's not a breach of contract action.
Your Honor, it is correct. The reason we raised it initially in the reply brief is Mr. Bell, in his answer brief, raised a number of the contractual provisions saying what had to be disclosed. That's why we wanted to
understand that the lawsuit was not
it's a
founded on
misrepresentation.
paragraph 7.
But
I mean, what my point was that it seems that you had a seller who knew exactly what the buyer wanted to do, and the seller knew that that could not be done. And when his agent says, oh, I think that's not a problem, I checked this record and that record in growth management, and I don't know what went through the seller's minds, but taking your facts as true, obviously the seller didn't say, wait a minute, you have to tell him those restrictive covenants are in place and he can't build condominiums. He didn't do that. He didn't reveal that. On the other hand, your client took a contract that clearly conveyed to him, we're not making any promises on multifamily development. I mean, that seems crystal clear in the additional language at the last page of the contract.
Your Honor, you are correct, but as I pointed out to Judge Rowe in response to her question, what did my client do when he saw that as-is language? He raised the issue with the seller's exclusivation.
I know,
but Your Honor,
the difficult thing here is he didn't walk away.
No, that is true, Your Honor, but again, the question is, he raised it with the seller's agent. The seller's agent then spoke to the seller and then came back to my client and says, I've spoken with the seller, I've sent him your concern, the as-is language will not prevent you from doing what you wish to do.
Okay, but the problem we have, and what Mr. Bell raises, is can the oral representations override the written contract here? And that seems to me like we're really opening up a Pandora's box.
Well, Your Honor, again, I disagree for this reason. Again, the contract says two things. One, I'm going to disclose everything that materially affects the value. Second, having done that, it's an as-is deal. And what Judge Green did below just looked at the as-is and just pushed aside the fact that, wait a minute, there was also a duty on the seller to make full disclosure, and then it's an as-is deal. And what my client did was, let's say, after the fact, something he probably shouldn't have done, he relied on a representation by the seller's agent that says, I checked with the seller, and the as-is language is not going to prevent you from doing this. Now, again, we're in the nature of fraud.
Mr. Manuel, your time is run. Thank you very much.
Thank you very much, Judge.
Okay, we invite everyone to join us in the attorney's comments for about 15-minute recess for a cup of coffee.